Welcome to San Joaquin College of Law Today, a show dedicated to issues and events within the law school which are of general interest as well. SJCL Today is produced by San Joaquin College of Law, a nonprofit law school in Clovis, founded in 1969 to provide quality legal education. Over 88% of its graduates have passed the California bar examination. More than a quarter of the practicing lawyers in the Fresno area are San Joaquin College of Law graduates. This edition of our program features our Constitution Day lecture for 2016 titled, "Don't Vote! Let the Rich People Run America as God and the Framers Intended." Constitutional law professor Jeffrey G. Purvis examines what the Founding Fathers had in mind when they were deciding who the deciders would be, and recent manipulations of voter rolls and voter rights as those seeking to obtain or maintain power try to tweak potential trickles of dissent.
And now, introducing me, a man who needs no introduction because there's nobody to introduce me. Are we ready? Welcome to San Joaquin College of Law's Constitution and Citizenship Day celebration for 2016. Why do I refer to this event as Constitution and Citizenship Day, you might be wondering? In part because the Kenyan Muslim Socialist Communist founder of ISIS proclaimed the following in 2009, quote, "In remembrance of the signing of the Constitution and in recognition of the Americans who strive to uphold the duties and responsibilities of citizenship, the Congress, by joint resolution of February 29, 1952, designated September 17th as Constitution and Citizenship Day, and by joint resolution of August 2nd, 1956, requested that the President proclaim the week beginning September 17th and ending September 23rd of each year as Constitution Week." Close quotes. This might be a propitious time to recite the following disclaimer as required by the Federal Bureau of Received Wisdom. Quote, "Professor Jeffrey G. Purvis makes frequent use of sarcasm and irony. SJCL apologizes in advance to everyone offended by his remarks. Any opinions expressed by Professor Jeffrey G. Purvis are his alone and do not represent the opinions of SJCL, KFCF, the State of California, or the United States of America, whose Constitution we celebrate today." Close quotes. I mention KFCF because this event is being recorded for broadcast on San Joaquin College of Law's Valley Views on the Law radio show on KFCF 88.1 FM, Fresno's own communist radio station. And if I may step out of character here for a moment and go into character as a professional radio host, please send lots of money to KFCF as soon and often as you can, because it's a voice for truth in an increasingly shrinking media world that gives a darn about truth, and it would be really helpful. Now back to our show. My co-host, Dean Justin B. Atkinson, is in the back of the room, simulcasting this program in Spanish to the growing Valley Views on the Law audience in Mexico, in Central and South America. "Diles de nuestra justicia, pero no las partes de miedo." Dean Atkinson also asked me to read the following, quote, "By listening to today's presentation, you agree to absolve and hold SJCL harmless from any and all liability of any kind whatsoever. You also agree to indemnify SJCL for any costs, expenses, damages, harm, or liability of any kind whatsoever that it might incur as a consequence of your existence, now and forever. Amen." Close quotes. And now, the segment that the vast multitude of listeners to Valley Views on the Law most looks forward to, Dear Professors, in which I read emails that I have fabricated from imaginary persons, then answer them in order to surreptitiously insert my discredited opinions into America's airwaves. Dear professors, I'm trying to figure out the Electoral College, which is, as I understand it, the mechanism by which the President and the Vice President of the United States are selected. Is it correct that the voters don't vote directly for the candidates of their choice? That they vote for electors who then get together and determine who will become President and Vice President? Why would the founders of the Constitution have set it up that way? What if the electors I vote for don't make the choice I want them to make? I think we should just scrap the Electoral College and vote directly for president. The person who receives the most votes wins. What could possibly be wrong with that? And that's from Bushwalker of East Rabbit's Foot, Texas. Mr. Walker, to understand the founders' actions in this regard, one must be aware of the political thinking that influenced them and of their natures. Many scholars believe that the founders were influenced by what has been called the Civic Republican tradition, deriving in part from the ancient Greek notion that politics was intended to instill virtue in its participants. The Civic Republican tradition did not value participation by all adults in political matters. A small group of educated, propertied men would select from among themselves the best leaders at a local level. Then these leaders would advance based on their merits to higher and higher offices, ultimately leading the nation. Women and non-whites were ruled by passions that would not lead to good decisions, and white males with no property could be controlled by the more powerful men via economic pressure. Thus, wealthy white males would control the government, and everyone else would accept this either because they had no choice or they had been cowed into believing that it was appropriate. The original proposal at the Constitutional Convention in 1787 was for Congress to select the president and the vice president. This plan was rejected because it was seen to give Congress too much power over the presidency. Instead, a plan was proposed for the election of president and vice president to be by a group of people apportioned among the states in the same numbers as their representatives in Congress, but chosen by each state in such manner as the legislature may direct. Some founders were influenced by the liberal tradition, which emphasized individual rights and suggested that direct popular election should be used. But the southern states, with much smaller voting populations, many of their inhabitants being slaves, would have objected strongly. Since the slave states received representation in Congress for 3/5 of their total slave population, those states would not be a disadvantage compared to states without slavery under the Electoral College system. James Madison felt that this system, which combined some aspects of popular vote with selection of the office holders by elites, would prevent the dangers of factions taking control of the government. Madison defined a faction as, quote, a number of citizens, whether amounting to a majority or minority of the whole, who are united and actuated by some common impulse of passion or of interest, adverse to the rights of other citizens or to the permanent and aggregate interests of the community, closed quotes. The statesmen selected through the civic republican process by their fellow elites would have no self-interest, being independently wealthy, and would learn to act solely for the common good. By allocating electoral votes to each state, even states with small populations would still have influence in the presidential election, since the states with large populations could not win outright by virtue of the number of ordinary votes they could produce. I should also note that when the electors voted for president, it appears to have been assumed that they would exercise independent judgment. No requirement is stated in the Constitution that the electors must vote for any particular candidate. And if no candidate obtained a majority of the elector votes, then the president was to be selected from among the highest scoring candidates by the House of Representatives. You can see, Mr. Walker, that this system was to avoid giving the rabble, the white men without property, a chance to use their votes to advance their selfish passions, such as a desire for equal opportunity, fairer economic conditions, and equal treatment under the law, to the detriment of a stable and beneficial status quo. Imagine how important this buffer between the greed-crazed voters and the government would become if women and people of color should ever somehow obtain the right to vote. If you doubt the wisdom of the framers, consider the 2000 presidential election. Without the Electoral College system, our president would have been Al Gore with 540,000 more votes than George Bush. With a pusillanimous Democrat in the presidency on September 11, 2001, instead of a proven Republican war hero, the terrorist would now be wreaking havoc all over the world. We should be hesitant to change a system that works so well. Why should we celebrate the Constitution of the United States? Other than the threat of withdrawal of federally insured student loans, is there any good reason to think that there is something special and wonderful about a more than 2 centuries old document? Not everyone thinks that the Constitution should be celebrated. Judge Richard Posner of the Fifth Circuit Court of Appeals, a prolific legal scholar and someone who has been mentioned as a possible Supreme Court nominee, does not agree. He recently said, quote, "I'm not particularly interested in the 18th century, nor am I particularly interested in the text of the Constitution." This is a federal judge, by the way. "I don't believe that any document drafted in the 18th century can guide our behavior today. Because the people in the 18th century could not foresee any of the problems of the 21st century, they should not be paid attention to." Judge Posner is a brilliant man. I certainly wouldn't dare to contradict his legal opinion. The people in the 18th century could never foresee a government using its power to oppress its own people, or invading the people's privacy, or seeking to silence those with whom it disagreed, or treating people differently because of their race or their religion. No, those poor saps blithering about a more perfect union and freedom of speech and their antiquated 19th century counterparts who gave us equal protection of the laws don't have anything important to say to 21st century judges. There's just one little problem with Posner's approach to judging. It completely abandons the rule of law in favor of the rule of the powerful. Creating the Constitution was a political act, but the most wonderful thing about the Constitution is that it places certain fundamental rights and liberties outside the ordinary political processes, so that those individual rights can be protected, even from majoritarian oppression. And the only way those individual rights can actually be protected is if judges enforce the Constitution's limitations on government power. Paying attention to the Constitution does not mean that we must be ruled by the dead hand of the past. Some legal philosophers have argued that we should identify the values expressed by the often ambiguous language used by the framers and effectuate those values as best we can in the context of contemporary issues. Thus, the right to freedom of speech limits the government's power to regulate our communications, whether they take the form of paper pamphlets or tweets. The prohibition on unreasonable searches affects government's power to enter our homes, as well as its power to intercept our Instagram posts. Here is how Judge Posner decides the cases that come before him. Quote, "My approach with judging cases is not to worry initially about doctrine or precedent and all that stuff, but instead to try to figure out what is a sensible solution to the problem. And then, having found what I think is a sensible solution, without worrying about doctrinal details, I ask, is this blocked by some kind of authoritative precedent of the Supreme Court? If it's not blocked, I say fine. Let's go with the common sense sensical solution, close quotes. Thus, if a future president decided to expel all Muslims from the United States, Judge Posner would presumably ask himself whether this was a common sense solution to a modern problem, and if no Supreme Court precedent blocked it, uphold it as constitutional. Since the Supreme Court decision in Korematsu, which upheld the internment of Japanese Americans during World War II, has never been repudiated by the courts, Judge Posner might regard himself as free to approve the Muslim exclusion. A judge applying applicable precedents in good faith would subject the president's action to strict scrutiny because it targets people based on their religion. Even if the government argued that protecting America from terrorists was a compelling interest, the judge would find that expelling all Muslims was not the least restrictive means to accomplish that interest, because only a tiny percentage of American Muslims might be terrorists, and the expulsion would violate the rights of millions of Americans without any proof or suspicion that they represented any threat to national security. Of course, this is all academic speculation, because no American president would ever issue such a horrible unconstitutional order. My point is that a principled interpretation of the Constitution is critical to protect the rights of everyone. Speaking of the president, in November, America will choose a new president, and the process by which that is done and other public officials are selected is partially by vote, which is the focus of my presentation today. If you have enjoyed an SJCL Constitution Day presentation before, you know that I select outrageous titles in order to lure the unsuspecting public into attending so that I can use my powers of mind control to bend them to my political will. Today's official topic is, don't vote. Let the rich people run America as God and the framers intended. Who did the framers intend to control America? Why, the voters, of course. America is a republic. The people elect representatives who operate the government on our behalf for the benefit of all. Who are the voters? The Constitution, as originally ratified, had this to say about who would be eligible to vote and thus to participate in the self-governing body, we the people. Article 1, Section 3 stated, quote, "The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote." Article 1, Section 4 stated, quote, "The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations except as to the places of choosing senators," close quotes. Thus, the Constitution left the determination of who would be permitted to vote to the states, and there was no direct election by voters of U.S. senators. Many of the states continued the practice that was widespread in the colonies of permitting free white males who owned property to vote, although some states also permitted free white males who were taxpayers to vote. It was this that inspired me to frame today's topic in the manner I did. Of course, not all landowning white males or tax-paying white males are rich, except in comparison to many other Americans. And it didn't matter how rich or poor a woman or a person not white was. They were simply not permitted to vote. Many African Americans were owned as slaves and were permitted no political or other rights of any kind. How is it possible that the same people who wrote, "All men are created equal and are endowed with unalienable rights," could set up a political system that was so unfair? The short answer is they did not regard it as unfair. Many educated white men of that day accepted a society in which one group of people made all the decisions and everyone else obeyed those decisions. They followed a model originated in ancient Athens, which was called a democracy, where only white males who owned land were citizens and entitled to vote, comprising about 1/6 or less of the population. But that was then, and this is now. The Constitution has been amended so that no person may be denied the right to vote because of their race or their sex or their age, if they are 18 or older. No state presently requires that a person own property or pay taxes in order to vote in general elections. By amendment, U.S. senators are elected by the people of each state, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures. However, there is still no affirmative federal constitutional right to vote. Wait a second, Professor Purvis, say the constitutional scholars in the audience. I see one back there. What about the Supreme Court saying in Reynolds versus Sims that, quote, by denying some citizens the right to vote, such laws deprive them of a fundamental political right, preservative of all rights, close quotes. And Dunn versus Blumstein, where the Supreme Court said, quote, as a general matter, before that right to vote can be restricted, the purpose of the restriction and the assertedly overriding interest served by it must meet close constitutional scrutiny, close quotes. Don't statements like that indicate that the Supreme Court regards the right to vote as a fundamental constitutional right? Yes and no. Yes, because the court sometimes does describe voting as a fundamental right, but no, because it only does so in the context of an equal protection claim. In other words, the Constitution grants no right to vote, leaving it to the states to determine voter qualifications. But if the states permit some people to vote and forbid other people to vote, then the applicable classification may sometimes be subjected to strict scrutiny. To summarize, you have no federal constitutional right to vote. If your state permits anyone to vote, then they are subject to constitutional oversight in the classifications that are used to determine who votes and who doesn't. And you needn't worry about the legislature taking away or diminishing your right to vote, because for equal protection purposes, voting is a fundamental right, the regulation of which is subject to strict scrutiny, the next highest form of constitutional protection, except when it isn't. Consider the U.S. Supreme Court decision in Crawford versus Marion County Election Board in 2008. A recently enacted law required persons wishing to vote to present a government-issued photo identification, and it was challenged as a violation of equal protection. The theory advanced by the challengers was that even if a government-issued photo identification was issued at no cost, the difficulty of obtaining the requisite documentation required for that identification, such as a birth certificate, or of undertaking alternative methods of establishing identity, such as an affidavit executed at a government office, would preclude some eligible persons from being able to vote. Here is how I, as a law professor, would analyze this situation. The right to vote is a fundamental under equal protection, so strict scrutiny applies. The government must show that its action is necessary to further a compelling interest, and that the means chosen to effectuate that interest is the least restrictive on the challenger's rights. The government claimed that a photo identification was necessary to prevent in-person voter fraud, where the person seeking to vote is not really the person entitled to vote. In the abstract, this is certainly a compelling interest, since self-government would be severely harmed if persons not entitled to vote were able to vote via such fraud. However, another aspect of the compelling interest requirement is that the government must demonstrate that the claimed interest is actually implicated under the circumstances. Here is what the majority opinion in Crawford had to say, quote, the only kind of voter fraud that the photo identification requirement addresses is in-person voter impersonation at polling places. The record contains no evidence of any such fraud actually occurring in Indiana at any time in its history, close quotes. That would be sufficient, in my opinion, to fine for the challengers. The legislature took action which deprives some people of the right to vote for no reason or for some other reason than the one claimed. Of course, the Supreme Court majority in the Crawford case did not apply strict scrutiny to the challenge statute. Here is how the court described its standard. Quote, even-handed restrictions that protect the integrity and reliability of the electoral process itself are not invidious and satisfy the standards set forth in our previous cases. Rather than applying any litmus test that would neatly separate valid from invalid restrictions, we conclude that a court must identify and evaluate the interests put forward by the state as justifications for the burden imposed by its rule, and then make the hard judgment that our adversary system demands. Close quotes. I hope everybody can tell I'm trying to talk real pompous when I quote the Supreme Court. You say, no, Purvis, you always sound like that. The Crawford court described this as a balancing test. Quote, a court evaluating a constitutional challenge to an election regulation weighs the asserted injury to the right to vote against the precise interests put forward by the state as justifications for the burden imposed by its rule, close quote. A balancing test where the interests of the state are weighed against the interests of the challengers is not strict scrutiny and does not treat the interests of the challengers as a fundamental right. The interest of the state will almost always outweigh the interest of the selfish individuals seeking to set aside a law enacted by the majority of the people. The Supreme Court majority found that the state's interest in modernizing electoral machinery, cleaning up the voter rolls, and maintaining public confidence in the voting system outweighed any harm to the challengers. But I must read the following passage in the opinion dealing with the harm to the challengers. Quote, both evidence in the record and facts of which we may take judicial notice, however, indicate that a somewhat heavier burden may be placed on a limited number of persons. They include elderly persons born out of state who may have difficulty obtaining a birth certificate, persons who, because of economic or other personal limitations, may find it difficult either to secure a copy of their birth certificate or to assemble the other required documentation to obtain state-issued identification, homeless persons, and persons with a religious objection to being photographed. If we assume, as the evidence suggests, that some members of these classes were registered voters when the new voter law was enacted, the new identification requirement may have imposed a special burden on their right to vote. The severity of that burden, of course, is mitigated by the fact that, if eligible, voters without photo identification may cast provisional ballots that will ultimately be counted. To do so, however, they must travel to the circuit court clerk's office within 10 days to execute the required affidavit. It is unlikely that such a requirement would pose a constitutional problem unless it was wholly unjustified, which I thought I just demonstrated it was. And even assuming that the burden may not be justified as to a few voters, that conclusion is by no means sufficient to establish petitioners' right to the relief they seek in this litigation, close quotes. To the Supreme Court justices, the danger that a few fraudulent votes that had never been shown to occur might change the outcome of a close election demonstrates the legitimacy of the state's asserted interest. But the acknowledged loss of the fundamental constitutional right to vote by a few poor people does not outweigh the government's justifications. And we must take note of the following, quote, in their briefs, challengers stressed the fact that all of the Republicans in the General Assembly voted in favor of the photo ID requirement, and the Democrats were unanimous in opposing it. It is fair to infer that partisan considerations may have played a significant role in the decision to enact the requirement. But if a non-discriminatory law is supported by valid, neutral justifications, those justifications should not be disregarded simply because partisan interests may have provided one motivation for the votes of individual legislators, close quotes. Let me offer my interpretation of that passage. Despite the fact that the Republican-controlled legislature enacted the photo identification voter requirement for the purpose of disenfranchising persons likely to vote Democratic in future elections, that is of no constitutional significance since the Republican legislators were able to manufacture bogus, not even plausible, non-discriminatory reasons for what they did. Oops. Looks like good old communist Professor Purvis of the communist radio station KFCF is letting his imagination run a little bit too free and too leftward in attributing improper motive to honorable state legislators. Let's explore the much more balanced take of a panel of federal appellate judges in the case of North Carolina State Conference of NAACP versus McCrory, decided July 29, 2016. In that decision, the federal court addressed the constitutionality of changes made to state voting laws. Here is how the challenge came about. And I'm reading from the Fourth Circuit's opinion. Quote, after years of preclearance and expansion of voting access, by 2013, African American registration and turnout rates had finally reached near parity with white registration and turnout rates. African Americans were poised to act as a major electoral force. But on the day after the Supreme Court issued Shelby County versus Holder, eliminating preclearance obligations, a leader of the party that newly dominated the legislature, Republicans, and the party that rarely enjoyed African American support, announced an intention to enact what he characterized as an omnibus election law. Before enacting that law, the legislature requested data on the use, by race, of a number of voting practices. Upon receipt of the race data, the General Assembly enacted legislation that restricted voting and registration in 5 different ways, all of which disproportionately affected African Americans. In response to claims that intentional racial discrimination animated its action, the state offered only meager justifications. Although the new provisions target African Americans with almost surgical precision, they constitute inapt remedies for the problems assertedly justifying them, and in fact impose cures for problems that did not exist. Thus, the asserted justifications cannot and do not conceal the state's true motivation. In essence, the state took away minority voters' opportunity because they were about to exercise them. As in previous cases, this bears the mark of intentional discrimination. Closed quotes. I should point out here that the U.S. Supreme Court struck down the preclearance requirement in the Voting Rights Act in the Shelby County versus Holder case mentioned by the Fourth Circuit, in important part because Congress had failed to consider current conditions. In the Supreme Court majority's view in Holder, voting rights and other rights have improved so dramatically for African Americans over the past 40 years in the former hotbeds of race discrimination like North Carolina that it was simply irrational to apply the mechanism of the preclearance requirement to North Carolina now. The Supreme Court in Holder also found that preclearance requirement offended the equal sovereignty of the states. You will undoubtedly agree that the decision in McCrory vindicates the U.S. Supreme Court's judgment that racism no longer exists in places like North Carolina. It is startling and gratifying to see how the North Carolina legislature had, in the manner of former Stephen Colbert character, become colorblind. Here are excerpts of the findings of the trial court as described by the Fourth Circuit Court of Appeals in McCrory. The law required in-person voters to show certain photo IDs, beginning in 2016, which African Americans disproportionately lacked, and eliminated or reduced registration and voting access tools that African Americans disproportionately used. Prior to enactment of the voting statute, the legislature requested and received racial data on the usage of the practices changed by the proposed law. This data showed that African Americans disproportionately lacked the most common kind of photo ID, those issued by the Department of Motor Vehicles. The pre-Shelby County version of the voting law provided that all government-issued IDs, even many that had been expired, would satisfy the requirement as an alternative to the DMV-issued photo IDs. After Shelby County, with race data in hand, the legislature amended the bill to exclude many of the alternative photo IDs used by African Americans. As amended, the bill retained only the kind of IDs that white North Carolinians were more likely to possess. The district court found that prior to enactment of the new voting law, legislators also requested data as to the racial breakdown of early voting usage. Early voting allows any registered voter to complete an absentee application and ballot at the same time, in person, in advance of Election Day. Early voting thus increases opportunities to vote for those who have difficulty getting to their polling place on Election Day. The racial data provided to the legislators reveal that African Americans disproportionately used early voting in 2008 and 2012. In particular, African Americans disproportionately used the first 7 days of early voting. After receipt of this racial data, the General Assembly amended the bill to eliminate the first 7 days of early voting, shortening the total early voting period from 17 to 10 days. As a result, the voting law also eliminated one of 2 Souls to the Polls Sundays in which African American churches transported voters to the polls. The district court found that legislators similarly requested data as to the racial makeup of same-day registrants. Prior to the new voting law, same-day registration allowed eligible North Carolinians to register in person at an early voting site at the same time as casting their ballots. Same-day registration provided opportunities for those as yet unable to register, as well as those who had ended up in the incomplete registration queue after previously attempting to register. Same-day registration also provided an easy avenue to re-register for those who moved frequently and allowed those with low literary skills or other difficulty completing a registration form to receive personal assistance from poll workers. The legislature's racial data demonstrated that, as the district court found, it is indisputable that African American voters disproportionately used same-day registration when it was available. The district court further found that African American registration applications constituted a disproportionate percentage of the incomplete registration queue. The court found that African Americans were more likely to move between counties and thus more likely to need to re-register. As evidenced by the type of errors that placed many African Americans in the incomplete application queue, in-person assistance would likely disproportionately benefit African Americans. The new voting law eliminated same-day registration. Legislators additionally requested a racial breakdown of provisional voting, including out-of-precinct voting. Out-of-precinct voting required the Board of Elections in each county to count the provisional ballot of an Election Day voter who voted in the wrong precinct, but in the correct county for all of the ballot items for which the voter was eligible to vote. This provision assisted those who moved frequently or who mistook a voting site as being in their correct precinct. The district court found that the racial data revealed that African Americans disproportionately voted provisionally. In fact, the General Assembly had already enacted the out-of-precinct voting legislation that enacted it had specifically found that of those registered voters who happened to vote provisional ballots outside their resident precincts in 2004, a disproportionately high percentage were African American. With the new voting law, the General Assembly altogether eliminated out-of-precinct voting. African Americans also disproportionately used pre-registration. Pre-registration permitted 16 and 17-year-olds when obtaining driver's licenses or attending mandatory high school registration drives to identify themselves and indicate their intent to vote. This allowed County Board of Elections to verify eligibility and automatically register eligible citizens once they reached 18. Although pre-registration increased turnout among young adult voters, the new voter law eliminated it. The district court found that not only did the new voting law eliminate or restrict those voting mechanisms used disproportionately by African Americans and required IDs that African Americans disproportionately lacked, but also that African Americans were more likely to experience socioeconomic factors that may hinder their political participation. This is so, the district court explained, because in North Carolina, African Americans are disproportionately likely to be poor, less educated, have less access to transportation, and experience poor health. The Fourth Circuit in McCrory, after a very lengthy analysis, said this, quote, "The record thus makes obvious that the problem the majority of the General Assembly sought to remedy was emerging support for the minority party. Identifying and restricting the ways African Americans vote was an easy and effective way to do so. We therefore conclude that race constituted a but-for cause of the challenged voting law, in violation of the Constitution and statutory prohibitions on intentional discrimination." Closed quotes. Please hold your applause. Donald Trump has taught us that if a judge doesn't rule in your favor, it is because he is biased against you. For example, if he is a Mexican. The Republicans immediately claimed that the three-judge panel that decided the McCrory case was biased against them because those judges had been appointed by Democratic presidents. Compare that reaction to what Al Gore, winner of the most votes in the presidential election of 2000, did when a U.S. Supreme Court majority of Republican-nominated justices shut down the recount of the Florida presidential ballots and declared that George W. Bush should be president. Gore accepted the decision of the Supreme Court. What a fool. Gore should have shouted that the election was rigged, that the Republican justices were corrupt and biased against him, and urged his supporters to use their Second Amendment rights to set things right. But I digress. Shockingly, I'm usually so focused. That's right. There is one more aspect of the Fourth Circuit decision in McCrory that is noteworthy. Like many Supreme Court cases before it involving voting rights, the constitutional infirmity that the court identified as requiring reversal was not a violation of the fundamental right to vote, but the intentional use of racial discrimination by the government. Of course, I agree with the outcome of McCrory, but I fear that the focus on racial classifications diminishes the significance of the voting rights at issue and conceals the real purpose for which the North Carolina Republican leaders acted. What if the Republican legislature had not been targeting African Americans, or rather targeting them solely because of their race, but had instead been targeting them because they were expected to vote for Democratic candidates? If we remove race from the circumstances, what protection would the courts give the fundamental right to vote if a state legislature sought to use its power to make it more difficult for Democratic voters, independently of their race, to achieve political aims? The answer is provided in two U.S. Supreme Court decisions, Davis versus Bandemer in 1986 and Veith versus Jubilator in 2004. In Davis, Democratic voters in Indiana challenged the 1981 redistricting in the state done by a Republican-controlled legislature as an intentional attempt to minimize the possibility that Democratic candidates could be elected in the state. Here is how the Supreme Court framed its discussion of the critically important fundamental right to vote. Quote, "Our prior holdings foreclose any claim that the Constitution requires proportional representation, or that legislatures in reapportioning must draw district lines to come as near as possible to allocating seats to the contending parties in proportion to what their anticipated statewide vote will be. These holdings rest on a conviction that the mere fact that a particular apportionment scheme makes it more difficult for a particular group in a particular district to elect the representatives of its choice does not render the scheme constitutionally infirm. This conviction, in turn, stems from a perception that the power to influence the political process is not limited to winning elections. An individual or a group of individuals who votes for a losing candidate is usually deemed to be adequately represented by the winning candidate and to have as much opportunity to influence that candidate as other voters in the district. That certainly makes sense. You can be sure that President Trump will consider the interests of Muslim Americans just as well as he does those members of the Ku Klux Klan who have supported him in his election. I digress again. As proved at the trial court level in Davis, quote, Democratic candidates for the State House of Representatives had received 51.9% of the votes cast statewide. Sorry to make you do math. And Republican candidates 48.1%. Out of the 100 seats to be filled, Republican candidates won 57 and Democrats 43, close quotes. And here is how a dissenting opinion characterized the facts of that case. Quote, the district court found that the procedures used in redistricting Indiana were carefully designed to exclude Democrats from participating in the legislative process and consisted of nothing more than the majority party's private application of computer technology to map making. The only data in the computer program were precinct population, race of precinct citizens, precinct political complexion, and statewide party voting trends. Next, the district court found how the map makers carved up counties, cities, and even townships in their efforts to draw lines beneficial to the majority party, closed quotes. Remember, the right to vote is fundamental. According to Supreme Court equal protection jurisprudence, government interference with the right to vote should receive strict scrutiny. The evidence in Davis showed that the Republicans purposefully drew voting district boundaries for the sole purpose of minimizing the electoral success of the Democratic candidates and succeeded. A minority of Republican voters elected 57 out of 100 legislators, an overwhelming Republican majority in the legislature. But the plurality writing for the court held that relying on a single election to prove unconstitutional discrimination is unsatisfactory. There was no finding that the 1981 reapportionment would consign the Democrats to a minority status in the Assembly throughout the 1980s, or that the Democrats would have no hope of doing any better in the reapportionment that would occur after the 1990 census, close quotes. And then this, quote, we recognize that our test may be difficult of application. Determining when an electoral system has been arranged in a manner that will consistently degrade a voter's or a group of voters' influence on the political process as a whole is of necessity a difficult inquiry. Nevertheless, we believe that it recognizes the delicacy of intruding on this most political of legislative functions. Close quotes. Running a computer program to make sure your political opponents, though numerically superior, will be a powerless minority in the legislature is just too delicate a problem for the Supreme Court to undertake. Democrats, you can come back in 10 years, and if you haven't been able to muster a majority in the legislature by then, we may consider your arguments at that time. The decision in Veith versus Jubilator gave free rein to partisan gerrymandering for the purposes of diminishing the voting power of political opponents. I sure as hope we do that in California, the Republicans. I have to check into that. In that case, 5 justices held that political gerrymandering cases were non-justiciable, meaning that courts had no jurisdiction to review such claims. This was because there were no judicially discernible or manageable standards with which to adjudicate the claims. According to the plurality, if a person believed that she had been deprived of her right to vote because the state legislature had drawn district lines to minimize the voting power of her political party, she must seek a remedy from Congress. I can't even say that with a straight face, which has constitutional authority to alter district lines drawn by state legislatures. This also makes sense. If the Republican-controlled state legislature has drawn congressional districts in the same manner as in Davis versus Bandemer, resulting in a large majority of Republican congresspersons, then a Democrat asking a Republican Congress to protect her voting rights is sure to get a warm reception. Justice Kennedy joined in the judgment of the court in Veith, but said, quote, that a workable standard for measuring a gerrymander's burden on representational rights has not yet emerged does not mean that none will emerge in the future, close quotes. Justice Kennedy has been described by pundits as the swing vote on the Supreme Court, at least while Scalia was still alive. Kennedy is the great uniter of the court. Someday the Supreme Court will be able to protect your voting rights, he tells us, after Republican-dominated legislatures have ensured that a Republican-dominated Congress and a Republican president have filled the Supreme Court with more Roberts, Alitos, Scalias, and Thomases. My constitutional law theme today, which I hope you will all celebrate, along with your citizenship, is that whatever your right to vote, it is precarious and under attack from several quarters. The Supreme Court in Yickwo versus Hopkins wrote this about voting, quote, though not regarded strictly as a natural right, but as a privilege merely conceded by society according to its will under certain circumstances, nevertheless, it is regarded as a fundamental political right because preservative of all rights, close quotes. What a stirring endorsement. Voting is a privilege merely conceded by society. And who controls society? I return to my topic for today, rich people. The rich people and corporations who finance politicians' political campaigns. The rich people and corporations who pay hordes of lobbyists to wine and dine legislators and fill their ears with the rich person's perspective on political issues. The rich people and corporations who fund opposition campaigns to ballot initiatives that seek cleaner air and water, purer food, greater access to medical insurance, and lower prices for medications. I leave you with 2 entreaties this evening. First, whoever you are, vote. Fewer than half of the people eligible to vote, often far fewer, don't bother to vote at all. Second, all of you who seek to amend the Constitution, come together and direct all your efforts at making explicit that each person has a fundamental constitutional right to vote in all federal and state and municipal elections for which they would qualify by citizenship and residency. Then perhaps our federal courts, the guardians of our liberty, would take the right to vote seriously. Thank you. We have 7 minutes for Q&A. It's just like my common law class. Yes, sir.
Isn't it because strict scrutiny has never been opened up to non-fundamental rights or things not going at suspect classes? Isn't that why the Supreme Court refuses to expand its power to include voting registration, voter ID laws into strict scrutiny?
Well, if I understand the premise of your question correctly, which I would frame differently, strict scrutiny is the applicable standard of review when a fundamental right is involved. The Supreme Court has repeatedly said that voting is a fundamental right. So by their own jurisprudence, they should be applying strict scrutiny. It wouldn't be any expansion. It would just be following their own rules.
But isn't that mere dicta?
Which is mere dicta.
When they state that it's a fundamental right, if it's not explicitly stated in the Constitution and enumerated, then is it not then just a companion right?
I hope you're planning to enroll, if you haven't already, at San Joaquin College of Law, so that you could take my constitutional law class and we could discuss this at length. But there are numerous non-explicit implied fundamental rights in the U.S. Constitution. So short answer to your question is no. Thanks for asking. All right, well, again, everyone, thank you for coming. I hate big crowds, so I appreciate that too. See you all next year.
And that brings us to the end of this edition of San Joaquin College of Law Today, presented by San Joaquin College of Law, a nonprofit law school committed to educational excellence and community service. The views expressed do not necessarily reflect the position or views of San Joaquin College of Law. This program has been produced in conjunction with the Community Media Access Collaborative. We invite you to join us in the future as we explore issues and events within the law school which are of general interest as well. For more information about San Joaquin College of Law, please visit our website at www.sjcl.edu or call 559-323-2100.